Just to be safe, knock it off.
Good afternoon, everybody. This is First Appearance Court. You're here because you've been charged with a criminal offense. My name is Steven Zachor. I'll be your judge this afternoon. The purpose of today's hearing is to let you know what you've been charged with, for me to determine if there's probable cause to hold you for those charges, and determine any release conditions if appropriate. You're all charged with a criminal offense. You have a right to remain silent. Anything you say is recorded. Anything we all say is recorded. So if you talk about the facts of your case, and you say something that the state of Florida finds useful against you, they'll have it documented and preserved to use it in the future. I suggest you exercise your right to remain silent and do not talk about the facts of the case. When you address the court, just confine your comments to your ties to the community, your financial situation, and things of that nature. You are entitled to a lawyer for the purposes of these proceedings. There's a member of the Public Defender's Office there in the jail. It's probably Mr. Miller. And then in the courtroom here is Mr. Afzal, who's also here for your assistance. I'm going to start with Roberto Rafael Masori. Good afternoon, sir. You are charged with one count of domestic violence battery. Mr. Miller there, is the lawyer there? There he is. Okay, you are charged with one count of domestic violence battery. I reviewed the probable cause affidavit. I do find probable cause. Any criminal history for Mr. Masori?
Possession of marijuana paraphernalia, 2014.
That's it?
That's all I see.
Contact?
There was no contact.
Oh, on the other one, I didn't know how
Good
you,
afternoon.
I didn't see that. I'm looking at this one. Okay,
Mr. Miller?
so he's due. All right, let's be patient.
Mr. Masori has been living in South Florida for about 6 years. He does have family here, including his parents, his brother, his sister, uncles, aunts, cousins. He's currently was injured about a week ago. He's currently not working, but he does have a job. He's just recovering. He does not have money to post a bond. He does have a place to stay that's separate from the alleged victim, and he'll be asking his girlfriend to bond him out.
Okay, it's going to be a $100 bond. There's to be no contact directly or indirectly with Carlos Alberto Masori until further order of the court.
Thank you very much, Your Honor.
Please see Alma Machado.
Out the door. There you go. Sir, please walk down the center and go away from the hall. Thank you. Here's Ms. Machado, President of the Maine.
Good afternoon, Ms. Machado. You are charged with one count of battery causing great bodily harm. I reviewed the probable cause affidavit. I do find probable cause. Yes, this is not a domestic. This is not a domestic.
No. So.
Your bond is $1,000. As a condition of your bond, you need to not have any contact whatsoever with Lucy Sepulveda.
No problem.
Thank you.
Thank you. So what do you say? I got $100.
$1,000 bond, $100 to embarrassment, and no contact. Thank you.
All right.
Hurtado is bonded.
Okay, thank you.
De Los Santos.
Here.
Carla Tatiana de Los Santos.
President of the Maine Jail. This time, Judge, we would invoke Ms. De Los Santos' right to remain silent. Advise the court that Ms. De Los Santos does not wish to speak to anyone regarding this or any other matter, and that if anybody wants to speak to her, they should first talk to her attorney and contact them through the Public Defender's Office.
Okay, Ms. De Los Santos, you were charged in count 1 with robbery with a firearm. Count 2 is contributing to the delinquency or dependency of a child. I reviewed the probable cause affidavit. I do find probable cause for both charges. In addition, I find that the proof of guilt is evident and the presumption of guilt is great as to count 1. Therefore, you will be held no bond on count 1. There is no charge for count 2.
Thank you, Judge.
Brandy Pilawaski.
I think she's at North Broward, Judge. She has a MO case. I think Mr. McLawrence is coming back for that. Count 6.
All right. Ms. Pilawaski, you are charged in count 1 and count 2 with, well, it's not a charge. It's a warrant for your failure to show at arraignment in case number 15015-962 CF10A. In those same cases, you have 2 warrants for the revocation of your pretrial felony release. Count 5 is a violation of your misdemeanor probation in case number 14066-181 TC 30A. And last but not least, you have a warrant for a municipal ordinance case out of the city of Fort Lauderdale, case number 020017778 M010A. You'll be held no bond on counts 1 through 5. You'll see your judge on the felonies on Wednesday the 24th at 8:45. You'll see your judge on the misdemeanor on Friday the 26th at 10 a.m. And you have a $250 bond on the municipal ordinance. I guess we'll keep you around in case Mr. McLawrence comes back and we can resolve these charges if that's what you're interested in. Okay? All right, so just go have a seat and we'll call you back in a few minutes. Horace Taiwan Gayi.
Conti.
Conti, Your Honor. Hey.
How you doing, Mr. Gayi?
How you doing, Your Honor?
You remember me?
Yeah.
How you doing?
You was a lawyer at the time.
Yeah, I was. All right. You have, looks like an ad charge of a violation of probation. It's case number 15001-920-MM30A. I don't know what your other charges are, but this is a violation of probation and you have a $100 bond.
Yeah, Your Honor, I want to let you know I was been incarcerated for this charge already, January the 8th of this month, last month. And they released me on this charge on RR.
When were you released?
I got this charge on January the 8th, and they released me on ROR on this charge.
Yeah, but Judge Mark signed a new warrant for you on February 8th.
Oh, man.
Yeah. So it's a $100 bond, and what they'll do is they'll give you a court date. I don't know what your other two charges are. This says this is count 3.
Okay.
All right?
All right.
Good luck to you.
All right, you too.
Vincent DePaul Beloga?
Main Jail Judge, Mr. Beloga is interested in resolving this case if the court is so inclined.
Good afternoon, Mr. Beloga.
Good afternoon, Judge.
Charged with 1 count of disorderly intoxication, public place, causing a disturbance. I reviewed the probable cause affidavit. I do find probable cause. You have a $25 bond. You want to resolve these charges?
Yes, sir.
Raise your right hand. You swear or affirm the testimony you're about to give is the truth and nothing but the truth?
Yes, sir.
Put your hand down, please. You understand by resolving these charges, you'd be giving up your right to contest them in court, giving up a right to a trial, giving up the right to confront the state's witnesses, call your own witnesses, have a lawyer such as Mr. Miller advocating for you at trial. You'd also be giving up your presumption of innocence. You don't give up those rights?
Yes, sir.
How do you plead, sir?
We might need you to go back up.
No contest
All right. I'll accept that no contest plea as a knowing and voluntary waiver of your rights. Now, I read this probable cause affidavit, and you can't be doing stuff like this.
Yes, sir.
All right?
Yes, sir.
I mean, I know it's in the grand scheme of things, it's fairly minor, but, you know, people don't want to have to put up with that.
Yes, sir.
So I don't want to have to see you back again on something like this.
I won't be, sir.
You do whatever you want to do as long as you're not hurting other people, okay?
Yes, sir.
All right, I'll send it to you an adjudication in the time you've already served.
Thank you, sir.
Wayne
Good
Anthony
luck, Mr.
Samuels.
Beloga. Main Jail.
What's going on today?
Come on up.
Good afternoon, Mr. Samuels. You are charged in count 1 with operating without a valid driver's license. Count 2 is possession of marijuana less than 20 grams. Count 3 is possession of an open container in a motor vehicle. Count 4 is temporary tag expired 7 days or less. And count 5 is traffic ticket. Careless driving. The last 2 are traffic tickets. I reviewed the probable cause affidavit. I find probable cause. You have no charge on count 1. There's a $100 bond on count 2. No charge for counts 3, 4, and 5. So your total bond is $100.
Thank you, Judge.
Thank you, Judge.
Good luck, sir.
Matthew Olasinski.
No 4 hours, Your Honor.
Stand on the X.
Judge, he declined the public defender's office, but I would be asking for a mental health screen.
Good afternoon, Mr. Olasinski. You are charged with 1 count of resisting an officer without violence.
This is a reset.
The reset. Let me remember this one.
This is over there somewhere.
I reviewed the probable cause affidavit. I do find probable cause. Your bond is $100. How you feeling?
Not sure.
I'm sorry?
Not sure.
You're not sure how you're feeling? All right, I'm going to order a mental health screen, and I'm going to transfer this to Judge Ginger Lerner Wren. Carl Mitchell Thompson.
Yes, sir. Main Jail Judge, Mr. Thompson would like to resolve this case if he can.
Good afternoon, Mr. Thompson. You have a warrant in case number 15004-089-MM40A. That is for petty theft. And it looks like it's not in custody. Mr. Linder, do you have a police report or anything? I don't, it's a warrant. I don't have any of the information about the offense.
What's the case number?
15004-089-MM40A.
Okay. You want me to print it out or give you the sum and substance?
Whatever's easier.
All right.
Is it a shoplifting?
Yes.
Fair.
Trying to find the name of the place. CVS, September 29th last year.
Property recovered.
Well, it looks like it, but it says he shoved it into the property in his pants, so I don't know what they did with it, but
Okay. What's the value?
$72.31.
Okay. Mr. Thompson, Mr. Miller tells me you'd like to resolve these charges.
Yes, sir.
All right, raise your right hand.
Yes, sir.
You swear or affirm the testimony you're about to give is the truth and nothing but the truth?
Yes, sir.
Put your hand down. You understand by resolving these charges, you'd be giving up your right, your constitutional rights, such as your right to fight this in court, call your own witnesses, confront the state's witnesses, have a lawyer like Mr. Miller advocate for you on your behalf. You'd be giving up your right to, you'd be giving up your presumption of innocence as well. You want to give up those rights?
Yes, sir.
You understand this is a petty theft charge, which is generally speaking a misdemeanor, but if you get enough of them, they turn into felonies. So, I don't know your full record, but if you have any petty thefts in the past, this could put you into felony territory. Is this still something you'd like to do?
Yes, sir.
You understand that a subsequent petty theft could turn into a felony?
Yes, sir.
All right. How do you plead then, sir?
No contest, sir.
All right. I'll accept your no contest plea, and I will sentence you to an adjudication in time served.
Thank you, sir.
Good luck to you. Matthew Burns. Good afternoon, Mr. Burns. You have two violation of probation warrants in case number 03002-527 CF10A and 030000919 CF10A. You'll be held no bond on those. You will see your judge in Division FE on Wednesday at 8:45 in the morning.
All right, thank you, sir.
Good luck to you. David Michael Lancy.
Yes, sir.
Good afternoon, sir. You have two violation of probation warrants for you as well in case numbers 14009-455 CF10A and 11009890 CF10A. You will be held no bond on both of those, and you will see your judge in Division FG
Next one.
on Wednesday at 8:30 in the morning.
Thank you.
Main Jail Judge.
Carlos Orlando Ramirez. Good afternoon, Mr. Ramirez. You are charged in count 1 with driving under the influence of alcohol or drugs, fourth or subsequent offense. Count 2, refusal to submit to a driving under the influence test. And count 3 is driving on a suspended or revoked license. I reviewed the probable cause affidavit. I do find probable cause.
How long you live in South
Well,
Florida?
that's, what is he, going out of state?
This is fourth, and this one right here is fifth.
Well, first of all, he's permanent revoked. Also. So that's another
Looks
felony.
like the DUIs are from 88, 93, and 93.
He's got one from 09,
I didn't see that one.
Bay County,
Oh, here it is.
and that caused his license to be permanently revoked in 2010. So it's looking like he's going to end up, assuming these charges get filed, it looks like he'll get charged with a felony.
Meaning
And-
count 3.
Yes.
One's already a felony, correct?
Yeah, count 3.
Any other criminal history other than the DUIs?
Get an injunction placed against him, order of protection 2008. That was on a battery. Possession of cocaine, out of date 99. Disorderly conduct 95 in date, end of record.
Mr. Miller?
Judge, Mr. Ramirez has been living here in South Florida for about 20 years. He has strong family ties, including his mother. Currently unemployed. He is, however, a registered voter. He has no money in the bank to bond himself out and no one to help bond him out.
Right here. Revoke your picture.
Okay, on count 1, it's going to be a $7,500 bond. Count 2 is a $100 bond, and as of right now, there's no bond on, I'm sorry, there's no charge, not no bond, no charge on count 3. If that gets changed to a felony, you'll deal with that when the time comes. So it's a $7,600 bond. It's going to be GPS monitoring upon release. No driving, no alcohol, no intoxicants. Good luck to you, Mr. Ramirez. Marquis Edward Wright.
Did you work prior to the judges?
Good afternoon, Mr. Wright. You're charged with 1 count of possession of cocaine. I reviewed the probable cause affidavit. I do find probable cause. Your bond is $1,000.
Thank you, Judge.
Corey Levon Cunningham.
Main jam. Space. You're next.
Yes, sir.
Good morning, good afternoon, Mr. Cunningham. You are charged in count 1 with possession of cocaine. Count 2 is a parole violation. I've reviewed the probable cause affidavit. I do find probable cause. There's a $1,000 bond for the possession of cocaine. You'll be held no bond on the parole violation.
Yes, sir.
Good luck to you, Mr. Cunningham.
Eugene Pace.
Yeah, that's what David said. That's what I want.
Here you go.
Good afternoon, Mr.
Cunningham.
Pace. You were charged with aggravated battery with a deadly weapon. I reviewed the probable cause affidavit. I do find probable cause.
Checking that right now.
Assault and strong arm robbery.
Judge, the only thing we have, 1990 at a date, a burglary with assault or battery and a strong arm robbery.
Okay, Mr. Miller?
Judge, Mr. Pace has been living here in South Florida for about 50 years. He has strong family ties, including his mother, his aunt, his cousin. He is a retired TV broadcaster. He has no access to his own money. He is a registered voter, and no one to help bond him out.
Here.
Okay, it's going to be a $5,000 bond. As a condition of the bond, there's to be no contact with Lanisha Lucille Bullard. Winston Charles Coley.
That's North Broward. It's a medical reset.
$5,000.
5,000. All right, Mr. Coley will be Tuesday at 1:30. Michael Eliza Shellman.
Shellman also is a medical reset, Judge.
Tuesday at 1:30.
No, come on, where's your stuff at?
William Brogno.
North Broward.
Put the court to a medical screen. And he's already appointed on the other cases.
Good afternoon, Mr. Brogno. Was it Brogno?
Good afternoon. Brogno, yes.
And sir, I just,
Good.
sir, I emailed your attorney. He
Okay.
emailed me back just right now. He'll be coming out to see you.
Okay.
All right, you're charged in count 1 with petty theft in the second degree. They say it's your third or subsequent offense, so that's a felony. Count 2 is providing false identification to a law enforcement officer. Count 3 is a warrant for your arrest in case number 16-000-346 CF10A. Counts 4 through 7 are also warrants for your arrest in case number 15-006-626 CF10A. Those warrants are for your failure to show up at arraignment. I reviewed the probable cause affidavit, and I do find probable cause for counts 1 and 2. You have a $750 bond on count 1. There's no charge for count 2, and you'll be held no bond on counts 3, 4, 5, 6, and 7. You'll see your judge on the 24th at 2 p.m.
Thank you.
And you wanted a medical screen? And I'll order a medical screen.
Thank you.
Miguel Allende.
Present the main jail, Judge. At this time, I would invoke Mr. Allende's right to remain silent. Advise the court that Mr. Allende does not wish to speak to any law enforcement officer about any issue, and that if any law enforcement officer anywhere wishes to speak to Mr. Allende, they should first contact his attorney through the public defender's office.
Okay, Mr. Allende, you have been charged in count 1 with robbery with a firearm, count 2, grand theft of a firearm, count 3, 4, 5, 6, and 7, possession of a weapon or ammunition by a convicted felon, and count 8, contributing to the delinquency or dependency of a child. I reviewed the probable cause affidavit. I do find probable cause
Judge, we would argue probable cause for 4, 5, 6, and 7. I don't think they get to count bullets, and there's no evidence that there was more than one firearm.
a step ahead of you. I agree with you. I do find probable cause as to counts 1, 2, 3, and 8. I do not find probable cause for 4, 5, 6, and 7. Additionally, I find that the standard of proof evident presumption great is satisfied as to count 1, the robbery with a firearm. Therefore, on count 1, you will be held no bond. Count 2 comes with a $1,000 bond. I guess I have to set a bond on count 3. You'll be ROR'd on 4, 5, 6, 7, and count 8 comes with a $500 bond.
And
Anything you want me to know regarding setting bond on count 3, Mr. Miller?
Judge will stay muted at this point.
Okay. He just got out of prison, right?
got out January 1st last year. It's actually, I think this is supervised. I don't know if it's probation or supervised release. carjacking, robbery with a firearm or deadly weapon.
Right, on January 2015, okay. All right, so count 1, as I said, is no bond. Count 2 is $1,000. Count 3 is going to be $15,000. ROR on 4 through 7 and 500 on count 8.
Judge, is that 15 or 50? 1-5 or 5-0?
Oh, Teresa's here.
Here we go.
I don't have a 10 and 11.
Yeah, there's.
I promise you, I don't have a 9, 10, and 11. I have 1 through 8. 1 is robbery, firearm. 2 is grand theft. 3 through 7 are weapon by felon, and 8 is contributing.
That's what he's saying, you don't have.
I don't have that. It's not on my face sheet. I see it's on the booking sheet now that I'm looking at it.
Oh, Your Honor. Then if you look at it's page 2 of the report, they wrote it in the introduction of contraband into the facility and the possession of cocaine and handwriting.
No, I see that.
Okay.
But I don't have one of these. Can I just write it on there?
Yeah, I think. Yeah.
Right. So 9 is what?
9 is his is the probation.
What's that case number?
0617151. It's a 94806 out of Lee County.
Okay. Count 10 is what?
Introduction of contraband into detention facility. And 11's possession of cocaine.
Okay, as to count 9 then, the violation of probation, that will be a no bond hold. Introduction into contraband facility, that'll be $1,000.
It's handwritten in the very end of the report.
Then possession of cocaine will also be $1,000. So, to reiterate and make clear, count 1 is no bond. Count 2 is $1,000. Count 3 is $15,000. 4, 5, 6, and 7 are ROR. 8 is $500. 9 is no bond. 10 is $1,000. 11 is $1,000. Okay, Patrice?
Okay, Judge.
This is
Mr. Sohit is a reception this morning. We're prepared.
Okay, just to remind you, Mr. Sohit, you are charged with 1 count of aggravated stalking after injunction for the protection against domestic violence. I guess you initially didn't want the public defender, rethought about it, and now, Mr. Miller, you've had a chance. So, Mr. Miller, did you hear his priors?
I'm familiar with his priors, Judge.
Okay, then go ahead.
I would argue there is no probable cause for aggravated stalking, Judge. In order to prove aggravated stalking, the state would have to prove that the defendant followed, harassed, or cyber stalked after an injunction. We're not going to argue about the injunction, but we don't believe that this probable cause affidavit has any evidence that speaks to either causing substantial emotional distress or conduct that serves no legitimate purpose. There's nothing in this probable cause affidavit that would allow the court to infer that there was no legitimate purpose for his contact with the alleged victim in this case, or that he caused her substantial emotional distress. And so I'd argue, Judge, that this is a simple violation of an injunction case, and that's a misdemeanor, and ask the court to find probable cause for that.
Your Honor, I'm printing out the. I've already.
Judge, I remember. I know Mr. Leonard gave me a copy of it, and there was one thing that did stand out. There were 3 previous.
I wasn't done.
What?
I wasn't done. I got like 3 words.
Did you need to say this again? Thank you.
I'm printing out, Your Honor, and I'll show defense counsel. In addition to what was put in the injunction, the reports, the PC reports for the 2 filed not in custody cases, Your Honor, and I think they show a pattern of Mr. Sohit violating this injunction. I think based on the totality that the court can make a determination based on probable cause that he is harassing this woman, that he's refusing to follow the injunction, and I think it reasonably follows that it would cause the average person stress and anguish, Your Honor. Just one moment. I didn't realize that we'd already put those up on Odyssey.
Yeah, I looked while I was waiting. I just
Okay.
looked. So those are the probable cause affidavits, case number 16-001-402 MF10A. Charges one count of stalking. 16-001-401 MF10A, which is a separate offense between the same defendant and same victim for stalking.
Yeah.
And incidents alleged to have occurred subsequent to the issuance of the permanent injunction issued by Judge, I think it was Kaplan, served upon the defendant on January 27th. So this probable cause affidavit then delineates the third such violation of the same injunction.
Yes.
Based upon that, I do find there is probable cause for aggravated stalking after injunction for the protection against domestic violence based upon the defendant's priors, which include possession of a firearm while under domestic violence injunction, battery, assault with a firearm. There's definitely some concerns there. So, Mr. Miller, did you get a chance to talk to Mr. Sohit? And I sort of did, but I didn't know
I'm
if you had
still
any...
arguing probable cause, and I haven't been able to make my argument yet.
Oh, I thought you did make your argument. I thought you made it quite
No,
clear.
I
But
wasn't.
anything else you want to add? Go ahead.
The state was supplementing their argument with previous contacts. Okay,
Right.
the first one, it says on the police report that it was January 27th. It's my understanding that that is a typographical error, that this is probably early in the morning hours of the 28th, where Mr. Sohit is alleged to have texted this woman that he was unhappy with the result of the hearing and that he wasn't going to go to his classes, which turned out, as it turns out, to be a idle threat, because he did in fact go to his classes at Glass Houses. He registered, and he's been going every Wednesday for an hour as prescribed by the court. The second contact, and so that was simply a text message. The second contact was at the Margate Sports Complex, where the children that these two people share play baseball. And so the allegation is that he went to this sports complex. It could be, from the totality of the circumstances, inferred that he went there to watch his children play baseball. And the fact that he approached the mother of his children with money could be inferred by this court that he was simply trying to contribute to the support of his children. Again, we're not seeing a pattern here, Judge. This is two isolated contacts, have nothing to do with each other, and both perfectly innocent. One is a text message in the wee morning hours. One is a perfectly reasonable approach in a public forum. And then we have the third, which is at this place where they used to live together. And there is no allegation in this probable cause affidavit before this court today that the behavior is repeated, that it is, causing substantial emotional distress, and that's what the state has to prove in this case, or that it served no legitimate purpose. There's simply nothing for the court to infer that exists. And so there is no probable cause that he aggravated stalked this woman. Again, it's just a violation of an injunction, and I would ask the court to find PC for that. There is no pattern of conduct here, Judge. Every contact alleged has been different. None of them have been harmful, and there is no allegation that she is under substantial emotional distress.
That looks like it. Thank you.
Judge, I would also note that in the injunction the court is reviewing, there were 3 instances where she was applying for an injunction, and that they were all the 3 previous ones were dismissed.
I didn't see my present.
Okay, pardon me, I just wanted to read through the injunction again. So, I understand your arguments, Mr. Miller, but I disagree, and I do find probable cause for aggravated stalking after an injunction. This is the 3rd such conduct since January 27th, when the injunction has been filed, and despite the fact that you might classify it as, I believe you said innocent behavior, it's in violation of the injunction, so therefore it's not innocent behavior. The
Judge.
injunction is very specific as to the time-sharing arrangements, when the children are in whose custody. So I cannot agree with you that it's simply innocent behavior.
Judge,
But I do find probable cause.
I'm sorry. I don't. I need to correct the court's characterization of my statement. I did not say it was innocent behavior. I said that the behavior did not necessarily serve no legitimate purpose, which is what the statute requires. There is no evidence, Judge, there is no allegation in the probable cause affidavit that his behavior served no legitimate purpose. This probable cause affidavit does not rise to the level of probable cause on its face, Judge. But I'm not trying to relitigate the issue. I just wanted to correct that statement.
Okay. Did you want to offer anything else regarding ties to the community or financial situation that Mr. Sohit did not otherwise provide? I'm going to have to do that again because I don't have a clear memory of what he told me before lunch on the ties. So.
Judge, I have some notes, 24 years, strong family ties, sister, mother, father, 2 children. That's all I got, and I guess you have the rest already.
Mr. Sohit, what were you doing again for work? Oh, you were selling insurance, right? And it was the slow season because open enrollment's over. Is that correct?
Yes, Your Honor.
Okay. All right, and Mr. Linder, just confirm for me the possession of a firearm while under an injunction for domestic violence.
Yes, Your Honor, one
Was
moment.
2012? And was that the same victim?
One moment, Your Honor. No, it was 2012. The alleged victim of the battery and ag assault that was dropped was a different member of his family, with the same last name. The alleged victim in this case was the alleged victim in a 2004 battery arrest that was dropped.
Right.
Your Honor, we would just the state would just be requesting, in addition to any monetary bond the court sets, based on now the 3 alleged violations of the injunction in less than a month. The petition that I provided you with a copy of, there was a previous threat to kill that Judge Kaplan felt credible enough that he ordered a permanent injunction. I'd be asking for a GPS monitor.
Okay, anything else, Mr. Miller, Mr. Sohit? All right, it's going to be a $15,000 bond. It's going to be GPS monitoring. And you need to abide by all the conditions of the permanent injunction that's already in place. So whatever the child sharing custody rules and regulations are that were put forth by Judge Kaplan need to be adhered to. They will remain the same. Understand that, Mr. Sohit?
You said yes, Judge.
Yes.
Do we have a John
Mr.
Toledo?
Toledo?
Is that Mr. Toledo?
Yes, sir.
And I believe we were waiting on Mr. Shate.
Yes, Judge, I'm here.
And
And Mr. Shate showed up. There he is. All right, Mr. Toledo, you were charged with City of Hollywood Municipal Ordinance for an open container. Actually, there's a warrant for your arrest in that case. It's case number 16-000-145-MO40A. Mr. Shade?
Yes, Judge, that's correct. I'm looking at the docket as well. Judge, we'd like to see if we could work this out today to a time-served plea. I did speak to Mr. Lanius earlier on in the day. That was, he's the city prosecutor for the City of Hollywood, and he has agreed for time served.
Mr. Toledo, would you like to resolve these charges?
it's not new. This is not new.
I'm sorry.
Can you hear me okay?
High pitch, low pitch.
I don't know what that means, but if you can't hear me, put your hand up, okay? I want to make sure you
Okay.
understand.
Mr. Toledo, this is your attorney, Stephen Shea. Would you like to accept a time-served plea and plead no contest to this? Maybe I have a low pitch.
Toledo.
There's an attorney here on your behalf.
Your attorney is over here. He wants to know if you want to accept a time-served offer and resolve your case today.
Yes, I do, please. No contest.
Okay, before you give me no contest, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth?
Yes, sir.
All right, you can put your hand down. You understand by resolving these charges, you'd be giving up your constitutional rights, such as your presumption of innocence and your ability to fight the charges in court.
Yes, sir.
Would you like to give up those rights and resolve these charges today?
Yes, sir.
How do you plead, sir?
No contest.
No contest, sir.
You did it so well the first time. Okay, I'll accept your no contest plea as a knowing and voluntary waiver of your rights and sentence you into adjudication and the time you've already served.
Thank you. You're
Good
done.
luck to you.
Adios. Thank you, sir. Mullins, Judge, I have Mullins and Richard Wilson.
All right, 1 second. I have
All right,
to,
Judge.
I have to hold true
I'd just
to the
like
promise that I
to
can.
apologize on behalf of the court, all the stress you guys go through. It's
Hey,
amazing.
just give me 1 second, sir. I didn't even hear a word you said, all right? I have to go to Paul Ryan first. Anybody at Paul Ryan? He's not going to know I kept my promise. Wow, that's a bummer.
Here he comes.
Oh, is that-
I'll let
Yeah,
him
he
know.
was running.
I'll let him know.
I remembered.
Remember, but we got 0.
Got nothing, but I still remembered.
Yes, sir. I appreciate that.
All right. All right, Mr. Miller, who you got?
Judge, second look docket. Jeffrey Mullins and Richard Wilson, they were arrested last week together in a parking lot on Fort Lauderdale Beach. They got to spend the weekend in jail, and they no longer want to fight this case.
Okay.
And they would like to resolve it if they can.
All right, Mr. Mullins, is that you up front?
That's Mr. Wilson.
I'm back, Your Honor.
All right, Mr. Wilson, whoever's up front.
You met Mr. Wilson last
I'm up
Monday,
front.
Judge.
Yeah, Mr. Wilson, I still
Wilson.
remember. This is the elbow room, right?
Yep.
Yeah, the elbow room again.
Yeah.
Well, no,
All
this
right.
wasn't.
Actually, the 7-Eleven.
This was actually the parking lot, Judge, across the street from 7-Eleven. So it's down the street and across the street. They were trespassed from the parking lot.
Oh, I guess it's a different one. All right, so you've been in
We're just
custody
gonna-
6 days on this, sir?
Yes, sir.
You'd like to resolve the charges and get it over with?
I would, sir.
Raise your right hand. You swear or affirm the testimony you're about to give is the truth, nothing but the truth?
Absolutely, sir.
All right, I guess I did Mr. Mullins and Mr. Wilson at the same time without even trying to, so that works. You can both put your hands down.
2 birds, 1 stone.
You've both been in custody 6 days. You both understand you're giving up your right to fight these cases by trial in court?
Yes, sir. Yes, sir.
Giving up your presumption of innocence?
Yes, sir.
All right, Mr. Mullins, how do you plead?
I plead no contest, Your Honor.
Mr. Wilson, how do you plead?
No contest.
All right, I will accept both of your no contest pleas and sentence you both to an adjudication and I guess 6 days in Broward County Jail.
Thank you, sir. Thank you so much, sir.
Good luck
Thank
to
you,
you,
Judge. And
gentlemen.
that clears me at the main. May I be excused?
Yes,
All
sir.
right,
I'll
guys.
see you next
Thank
week.
Mr. Miller.
Thank you, sir.
No, you're stuck. Who do we have in North Broward?
I have Bates, Howell, and Trevi.
All right, let's look at Mr. Bates.
Bates first.
Judge, are we done with the MOs? I think we are.
Yeah.
Okay, okay. Thank you very much.
Ain't no bro, right.
Neither do I. Mr. Bates, you're here on a second look after 2 days? A little quick, isn't it, for a second look? Looks like you're in custody on a battery. Doesn't tell me what your bond is. Is it $1,000, I guess?
Like some happens where my number showed up on your phone.
2,500 with GPS. Okay.
Oh, Your Honor, this was Wesley Bates. Your Honor, this was upfiled. You can search in. It's a 30-day.
Oh, it's a 30-day?
Wesley Bates.
Yes.
Yes, it's a 30-day motion.
Oh,
It's been upfiled to a felony. I'll give you the felony case number. You can
it's on
check
my
it out.
second look, so that's why I was confused. We were doing a second look.
It's
after 2
all
days.
16 2257 CF10A.
And what was charged?
It's been upfiled to a felony battery due to prior conviction.
All right, Mr. Bates, apparently you were initially arrested for a misdemeanor battery. They allege you have prior convictions for battery that turned a misdemeanor into a felony. So you've been charged with a felony in case number 16002-257 CF10A. Do I have to set a bond or does he have a bond?
No, they'll just put whatever, either
on the felony battery.
Let me see.
So you might as well
Whatever-
set a bond right now.
Everyone,
I mean,
Sheila, if a DV misdemeanor is upfiled to a felony, will it go back to no bond for first appearance, or will they? I'm talking about in any situation. I know, that's why I'm asking you. If the state upfiles a misdemeanor domestic violence to a felony, will you guys, if it's upfiled to a felony, move the misdemeanor battery to the new felony, or will it be treated as no bond for first appearance? Okay, then Judge, I would just ask that whatever the release conditions that were placed on the misdemeanor just be placed on the felony.
All right, do that. So whatever your release conditions were, Mr. Bates, on the initial charge shall remain the same for the new charge.
They were,
Judge, would the court consider the time in as any mitigation to reduce them?
5,000 and no victim contact.
I was told it was 2,500.
I'll check to see if it was, I'll check.
That's just what I was told. I don't
Yeah, no, I'll check. Did Judge McHugh lower it? Okay, yeah, Judge McHugh lowered it to 2,500 in pretrial.
All right, so your bond is still $2,500 with GPS monitoring by pretrial. All right.
It's not GPS.
Okay, it's not. The
Standard
pretrial?
pretrial, special condition to enter First Step Sober House to complete First Step Sober. He has to report within 24 hours.
You get that?
Yes, sir.
All right. Good luck to you, Mr. Bates. Who's next at North?
Howell.
Timothy Howell.
Timothy Howell.
It's a 30-day.
Mr. Howell, you've been in custody for 30 days on possession of cocaine?
I've been here like 70 days. I've got bonded out. Since last year when I bonded out, I had 38 days time served.
Timothy Howell, he has an arraignment tomorrow morning.
Okay,
I'll-
looks like the
Well, no,
charges
it's-
against you have been filed.
Not in this case.
Not on this case? Different case?
That's probably why he's been in so long. He's got another case that was holding him.
On whatever other case is holding you, you have an arraignment tomorrow in front of Judge Matthew Destry.
Okay.
He can be ROR'd on this case.
This
I
case, the charges haven't been filed against you, so on this case and this case alone, you're entitled to an ROR. But whatever's holding you on that other case is still holding you.
All right.
Okay?
Okay.
Yeah,
Yes,
what
sir.
happened?
All about it.
Good luck to you, sir.
Thanks.
Had a bond surrender here.
What's your name, sir?
Gregory Tribby.
It's a second look misdemeanor.
Ma'am, come up to the podium.
Your name, ma'am?
My name is Susan McCormick.
Susan what?
McCormick.
Who are you, ma'am?
I am the girlfriend of Gregory Tribby.
Your girlfriend, okay. Mr. Tribby, you're here for second look. You've been in for, if this is accurate, 6 days on a trespassing. Your girlfriend, what, McCormick?
Susan.
Susan McCormick is here in court. So, is that correct? He's
That
been in
is
6
correct.
days on a trespass?
Yeah, sure. One moment. Well, was he transferred to Lerner Wren? For some reason, he was supposed to be reset for the 26th. Apparently, there might have been a mental health issue. Just looking at what Judge Hurley wrote on his.
While they're looking that up, what would you like me to know, Mr. McCormick?
Well, what I would like you to know is that I have information from the store owner. What had transpired is on the 17th, Greg Tribby had gone over to the laundromat to do laundry. He had been issued a verbal warning from Lighthouse Point Police to not trespass that particular store. But what had happened is there was an employee who had trespassed him. the store owner had told me that that particular employee had not been given the authority to trespass him because he didn't own the store. He was not the actual owner of the store. And she had told him, he'd gone there frequently. He'd been a frequent customer to come back to the store. She'd actually told him that it was okay to come back to the store. But what had apparently happened, he went over to get change, and when he did so, he went into the store, and the clerk that he had had problems with previously, who had filed the trespass, went ahead and called the police on him.
Okay.
And as a result, he was subsequently arrested. She is looking to go ahead. I had talked to her about this because when she found out about this, she immediately discharged this employee, terminated his employment, and essentially fired him for misconduct. This particular employee had numerous complaints as well as arguments with other customers. So this was not just something that happened with Greg, but this was an ongoing problem. When she found this out, she fired him.
Okay.
So she had gone ahead. I had spoken with her, and she is going to go ahead and try to submit paperwork to the state attorney's office to request that the case be dismissed.
Judge, while in the meantime, there's nothing to controvert what she's saying at this juncture. I would ask the court on this nonviolent offense to release him on his own recognizance. There may be a valid defense. I would ask the court to release him and allow him to pursue his legal defenses.
Does he live with you, ma'am?
Yes, he does.
And where do you folks live?
Lighthouse Point.
Is it like walking distance to this?
Yes, within a block and a half.
But how long have you two been together?
Roughly, it was May 20th, I think it was, of last year.
So not quite a year.
Right, not quite a year.
Whose place is it?
Mine.
You own it or you rent it?
I'm an owner.
And does he work?
He works with me. I do an animal rescue. I do
Is
that.
a volunteer position or a paid position?
No, I get paid. I do paid transportation. I go ahead and I pull animals, usually from Miami-Dade Animal Control, and I go ahead and I place them into homes throughout the United States.
And who do you work for?
Myself. I'm self-employed.
Okay. And who pays you then? The people that
The
ultimately
people,
adopt the dog?
right, exactly.
They pay some sort of a fee for the adoption?
Right, correct. And plus I also work for my father's company as well.
Doing what kind of work?
I had previously been a customer service rep for a number of years, but he owns a magazine company, and I go ahead and do work for him.
All right. And so Mr. Tribute lives with you, and that's the only work he does, is assisting you with this animal rescue?
Correct.
Does Mr. Tribute have any mental health issues or something like that that's going on?
That you'd have to ask him.
Well, you live with him since
Well,
you're 20. If you don't know,
I mean, as far as his mental health, I mean, he's stable. He's able to work. I mean, he does a lot of work around the house. It's just an unfortunate incident that occurred that landed him where he is today. But he had been doing very, very well.
okay. Mr. Linder, I can't pull anything up under the case number.
All right, it might be a little difficult to. It's not as bad as the case in this morning where I pulled the other report, but it's a little. You should. You can go by if you want. No, there's stuff. There's sensitive stuff in here that the court needs to be aware of.
Yeah, I don't think I evaluated 6 days ago, so I haven't.
No.
Information about what the incident.
Excuse me. Yeah, this is actually. No, this is Thursday. I was. Hey, just wait out. That's fine.
Oh boy. I can make through. This is a little better than that last one. Mr. Tribute, just so you understand, I was just handed the police report surrounding your arrest. I hadn't seen it before just now. So I'm reading
Yes,
that.
sir. Huh?
Okay. Did you have a chance to look at that? All right, and then
Judge, my point being is that regardless of what the PC says, there's somebody here from the community that says that he can go there. He may need some help. He could still go back to Judge Lerner Rent's courtroom. I mean, if he has a scheduled court date there, but I'd rather him go not being incarcerated as opposed to being incarcerated if there are issues, which are delineated in the report. I don't know, Judge.
Mr. McCormick, when you say he's lived with you continuously since May 20th, or more or less?
Yes, yes. He does a lot of work around the house. He had just gone ahead that day. He had previously worked he owned his own company, and he was a tiler. He did tile work.
Well, the reason I ask is because in the police report, there's mentioned by him of being homeless and needing homeless services.
No, he's lived with me. He's resided with me. I mean, he's been there every night except during this incarceration, so.
I believe she might have been talking about my past, sir.
Okay. How you feeling?
I'm feeling fine.
Yeah. Mr. Tribby, we're going to go off the record for a second so your lawyer can tell me something and he doesn't want broadcasted, okay?
Yes, I understand.
Ms. McCormick at a later date can tell you what we talked about. All right, Mr. Tribby, here's what I'm going to do. I'm going to transfer your case, if it hasn't already been transferred to Judge Ginger Lerner Wren's courtroom. You'll get a court date. If you're in need of any kind of services in the mental health arena, or even, as I understand it, in the homeless arena, that's the right place for you to be. In the meantime, I am going to allow you out. I will ROR you to the custody of Miss McCormick. Is that where you want to be?
Yes, sir.
All right.
Thank you, sir.
Seconded now, just talking to note.
There's no court date?
You're going to have to, I don't know if your proper is it 3850 Northeast 21st Street?
That is correct.
All right. So
Apartment 18. It's apartment 18.
Yeah, that's there.
Right.
That's where the court notice is going to be mailed. Now, you're going to have to look for that court notice, and you're going to have to see Judge Lerner Wren. It's going to be pretty quick. Might even be this week.
Yes, sir.
That's
So,
why you should check the
Be
clerk
proactive and
website.
go online and check the clerk of court's website to see when your date is, okay? Because then if they send you a
Yes, sir.
date and then you don't show up, you're going to be right back there again and less likely to be able to get out so easily. Not that this was easy.
Yes, sir.
Understood?
Yes, sir.
All right, good luck to you,
Yes,
Mr.
sir.
Tribby.
Thank you very much.
Thank you,
Your Honor.
sir.
Thank you very much.
Well, no, an ROR. It's gonna go back. It's not be released. All right. Anyone, nobody else at North, that's off.
Conti?
Conti?
No, we got felonies.
Your Honor?
Yes, sir.
Can Conti be first next Monday?
Who you got?
Dale Williams.
Dale Williams, wrong docket.
Walk behind him and have.
Mr. Williams been in custody. Looks like that's PvP.
Hasn't been-
without.
hasn't been
driver's
filed.
License. Not filed.
No.
Mr. Williams, you've been in custody for 30 days. They have not filed the charges against you as of yet.
45.
Okay, well, they still haven't filed the charges against you. That means you're
Yes,
entitled
no,
to an
sir.
ROR.
Yes, sir.
That doesn't mean the charges won't be filed. You just don't have to wait in jail any longer to see what happens. So,
Okay.
So if and when the charges are filed, you have to come back to court and deal with it, okay?
Yes, sir.
All right, so be proactive. If you don't show up, you're just going to get a no bond warrant issued for you.
I'll be here.
Yes, sir. Ma'am.
He came in.
Thank you.
Williams?
No, he can't.
Judge.
Can, he's ROR.
Can.
Can't put any conditions on it. Even if I want to. Are you Mr. Henderson? Okay, Mr. Henderson?
How you doing?
You've
How
been
you
in
doing,
custody in excess of 30 days on a possession of cocaine?
He can be ROR, Judge.
The state of Florida informs me they have not filed the charges against you as of yet. You are entitled to an ROR. Doesn't mean the charges won't be filed. It just means you don't have to wait in jail any longer to see what happens. But just like I told the last gentleman, you're going to get a court date if the charges are filed. You need to show up for that court date, or you'll have a no bond warrant out for your arrest. Understood?
Yes, sir.
All right, good luck to you.
Good luck to you too.
Thanks. Use it. I got one more here. What's your name, sir?
Gilbert Nicholas?
Nicholas?
Yes, sir.
It's on the misdemeanor.
I don't have it. Oh, Gilbert Nicholas, there it is. Violation of
Marijuana.
probation.
Yes.
That's what it says. Is it just the violation of probation, or is it a subsequent, is it a new charge? Oh, 6. That's what it says.
Sir, it seems that you have a violation of probation from 2006 for a possession of cannabis.
Yes.
If you got two options, you're being held no bond, but you have every right to fight these violations, and the state has to prove to the satisfaction of the conscience of the court that you willfully and substantially violated your probation. Now, that's your right. Or I can ask the judge that if you, I don't know what the violation is. What are they admitting? Well, I mean, what would he admit to?
I don't know, on here it says on March 12, 2014, the case was disposed.
No, it was. It says on what date?
June 21st, 2006, affidavit and warrant signed.
Yes.
9/6/2006, capias issued. And then on March 12, 2014, it just says disposed case status updated to disposed. And then on the 17th of February this year, warrant sold.
Just as maybe a warrant in error.
No. He was on probation until June 27th, 06, so the affidavit and warrant were filed in time.
Sir, did you resolve your case?
I thought I did, but apparently they said I had probation, I violated, so I got locked up.
But do you remember pleading this case out
Yeah, I thought
in
I did, yes.
2014?
Oh, no, not in 2014. I don't remember pleading it out. I was in Florida in 2014.
Yeah.
Okay. I thought you saw a disposition date in 2014.
No, then just magically in 2014, it says case updated and disposed. Your last name is Nicholas, correct?
Yes, sir.
No, because back then they weren't scanning, so I can't even look at it.
Do we know where we're going when we move into that one? Do we know? She said she doesn't believe that they don't go with us yet. Like our office is moving there.
We don't even.
Looks like he's the same guy who's on probation for possession of marijuana again. He's currently on probation according to this.
Judge, will the court consider ROR? He will be released of probation on the other case and see what's going on. I mean, sometimes may have been error. I'm not. I mean, if he was arrested or given a notice to appear for another possession of cannabis, and he's placed on probation. Now you're talking about a 2006 case popping up at the. Yeah. I mean, that doesn't make sense to me.
So there was a mistake.
It's all just paperwork, I guess.
Yeah, but you gotta understand, a warrant like this is probably only executable in Broward County, and he hasn't been arrested in Broward County since. No. What I'm saying is, with the warrant like this, even if he got arrested in Dade, they probably wouldn't. My suspicion is this warrant can only be executed in Broward County.
Ask him if he's on probation.
Are you on probation on any other case, sir?
I went to court on the 17th, and then they put me on probation for 4 months. And then when I went to go check in, they said I violated from 006, and I got arrested, and I'm here.
I don't know.
I don't know what he's talking about, because he was arrested on the 17th, but he couldn't have been put on probation for 4 months because what's in it?
Judge Hendricks.
For 4 months on this?
No, on a new case.
No, this was a new charge.
On a new charge he's on probation for. He went to check in, and then that's.
On February 17th, 2016, in case number 16-000-209 MM38, he was at arraignment. He pled no contest, adjudication withhold, counts 1 and 2.
That's really.
Administrative probation for 4 months, which I believe is an illegal sentence.
That's.
Done.
No, I don't know what to say, because.
Early term, prosecution of all conditions. He has to go to justice for life, whatever that is. Drug probes like a.
I don't. Then it's weird because it should be here.
It's Judge Marks.
Judge with the court ROR him on the 06 case.
What's the case number?
Yeah, please.
16-000-209 MM30A. Even if you got an NTA, the cops.
Okay, I understand now. Did he got arrested? Okay. I thought he meant he pled out that case after he got arrested for this. He pled that out before he got arrested on the VOP
And
warrant.
he went to report to probation, is what he's saying, and they picked him up for this warrant. What are your conditions of probation on the new case? What do you have to do?
I have to pay court costs for $400, and I had to take a class, and that's it. And then he'll take me off probation.
And you haven't done that yet, obviously, since you're here.
Nah, because I came here yet.
Okay. And it's the same judge that his probation is. All right. I'm ready to rule. Anything else? Anything else? All right, Mr. Nicholas, I'm going to ROR you on this violation of probation. Doesn't mean it goes away. You need to get it taken care of. You're going to get a court date. Is it going to get to be in front of Judge Marks now, or will it be here?
It'll get rescheduled in front of Judge Marks.
You're going to go see Judge Marks again, same judge who put you on probation to get this resolved, okay?
Yeah, thank you, Your Honor.
All right, you're welcome. Good luck to you, sir. I believe that's it. 2:54 p.m. Judge, pleasure.